Number 118, the matter of Jamie J. Good afternoon, counsel.
Good afternoon. May it please the court. Kate Woods of Legal Assistance of Western New York on behalf of the appellant, Michelle C. I'd like to request to reserve 2 minutes of my time for rebuttal.
You may have it.
Thank you. The purpose of Article 10 of the Family Court Act is clear. It provides a comprehensive framework for the family courts of the state of New York to determine whether a child has been abused or neglected.
Okay, so let me ask you this. Once, as in this case, a judge decides the DSS has not met its burden, denies the petition, does the judge have to sign a separate order so that the child is released back to the custody of the parent?
There's no requirement that the court sign a separate specific order releasing the child back. It's assumed that when a petition is dismissed and an order of dismissal is granted, that is what happens.
So there's not another step that the judge needed to take here?
No.
Doesn't the court have to hold a dispositional hearing?
Only if a finding of neglect or abuse is made.
there any-
So at the end of a fact-finding hearing, and he dismisses neglect, the way I read the commentaries, and Professor Sobey, that a dispositional hearing is then held.
If there is a finding, that's correct. These are bifurcated
You have
hearings.
a hearing. The court determines you didn't meet your burden of proof to establish neglect. And then they say, okay, what are we going to do? They have a dispositional hearing, right?
There is no dispositional
So your
hearing.
position is that immediately the parent would then take the child and walk out of the courtroom?
No.
Okay.
Article 10 contemplates this situation. In a case where there is a dismissal and a child is placed in foster care, there is an automatic stay on a return of the child until 5 p.m. the following business day. And that is specifically to address the concern here. If there are...
So I'm clear, though. Your position is there's no dispositional hearing?
Absolutely not. If there is no finding, there is no dispositional
Isn't that
hearing.
what we said in Tammy Z? I mean, in upholding the standard, didn't we say if you lose in the Article 10, the child immediately goes back?
Absolutely.
And
That's how the court...
we justified upholding the standard of proof in that case?
Exactly.
So during the period of the stay, that's when DSS can act if it feels that the child is in some kind of danger?
Exactly. The
And
DSS...
what exactly is the recourse available to DSS?
DSS can file an immediate appeal and request an ongoing stay pending the outcome of that appeal. And they could also file a new neglect petition articulating these new concerns they have and seek placement under that new docket. And indeed, in that case, eventually the department did bring a new neglect petition.
And before the petition is denied, or before the judge decides it, they can also seek to amend the petition?
Absolutely, and that is a common practice to amend the pleadings to conform to the proof.
Is that the error here?
I would argue that no neglect occurred on behalf of Michelle C. However, I think it would be a fair reading to say that the court perhaps should have permitted pleadings to be
Well,
conformed to the proof.
in all fairness, didn't the family court repeatedly tell DSS to amend their petition before trial?
Yes.
Can you shed any light on why it took more than a year from the removal to the fact-finding hearing?
That timeline is not uncommon for these cases. For many factors, this type of litigation tends to be slow. Docket congestion can often lead to that issue.
Counsel, is there any significance to the fact that Article 10 is silent as to when placement is terminated, when the underlying 1022 neglect petition is dismissed?
No, I think the idea of what happens after the dismissal of any petition is so basic to the practice of law that it is unnecessary to even state. Nowhere in the Family Court Act at all does it say what you do when a petition is dismissed, because it's obvious. The court no longer has the authority to act.
In this particular case, is the termination petition that has been since filed based at all on the duration of the time that the child has been in foster care?
There's an obligation on the county to bring a termination petition when a child has been placed in foster care for 12 of the most recent 15 months.
So if the court is allowed to continue jurisdiction under these circumstances, that could lead to a finding of permanent neglect without the parent ever having been found neglectful or abusive?
Absolutely. Your Honor mentioned the Tammy Z case, and I think that particular analysis is illuminating this case. And I would also point the court towards the matter of Marie B. In that case, the court held unconstitutional Section 1039 of the Family Court Act, which stated that upon a violation of an adjournment and contemplation of dismissal, there would be an automatic finding of neglect. And in finding that unconstitutional, this court articulated, and I can just read briefly from the decision, that legislation authorizing the removal of a child from the parent without the requisite showing of abandonment, surrender, persisting neglect, unfitness, or other like behavior evincing utter indifference and irresponsibility of the child's well-being constitutes an impermissible abridgment of fundamental rights, of fundamental parental rights, and that a constructive finding of neglect is constitutionally inadequate in terms of a justification for this. The analysis is the same in this case, but the posture is even more extreme. Here we reached the merits. There was a finding of no neglect, and to then say that placement can continue past that flies in the face of all the precedent that has come.
So assuming you're interpreting Article 10 correctly, what do we, in terms of the dismissal of the petition, what do we do with this plain language in 1022? The case shall remain on the court's calendar, and the court shall maintain jurisdiction over the case until the child is discharged, right? And that's from Article 10A.
Yes.
What do we do with that plain language?
The court's referencing the language from 1088.
Yeah, I'm sorry. I meant 1088.
That's okay. So there's two ways to think about this. One is that it states only that the court continues jurisdiction. 1088 continues jurisdiction. It does not create it. Jurisdiction to place a child in foster care exists.
So you would focus on that maintain. Maintain implies it already is there.
Right, something has to be in existence for it to be continued. And jurisdiction to place a child exists only in two places in Article 10, and that's temporary placement pending a final order of dismissal, which is exactly as it's articulated in the statute, or an order of disposition following a finding. But we can even look further at 1088. It says until the child is discharged from placement, and pursuant to this court's holding in matter of Tammy Z, we know that when a petition is dismissed, the child is discharged from placement. I would say, just to wrap up, the department in this case is seeking a solution to a problem that doesn't exist. There is no danger of children being returned to unsafe homes. The Fourth Department's decision does nothing to extend protections that are already afforded to children in this article, in this statute. All it would serve to do would be to unleash absolute chaos in the family courts across the state of New York. We ask the court to reverse.
Thank you, counsel. Counsel?
Yeah, Gary Bennett for DSS.
Mr. Bennett, I'm
Yes.
struggling. What is the predicate finding that allows the state to hold this child in its custody?
Well, I believe the Fourth Department dissent thought it was the removal order. It wasn't. We had a first permanency hearing order. and
First
that-
what?
The first permanency hearing order continued the child in foster care. And frankly, the problem we have in this case is, at the time the neglect was dismissed, the child was what I'll call on the Article 10A track. The child was placed under 10A.
So you're,
Wasn't 10A enacted in the first place as a corollary in other words, to track the placement of children who have been placed under Article 10? How is it possible to view, and where else do you get any support for your argument that 10A is some separate track
Because
from
what-
Article 10?
Because the problem, from a practice point, is when they created 10A, they took the extension out of Article 10, where it was forever, and they created this whole new Article 10A, a whole separate section of the Family Court Act. And they created that language in 1088 that says a court has subject matter jurisdiction. My understanding of the appellant's appeal is that she's arguing the court didn't have subject matter jurisdiction, but my thought is if you read 1088, it clearly says the court has subject matter jurisdiction.
so your theory is that if the fact-finding had actually occurred, the fact-finding hearing had occurred and the disposition of that hearing had occurred in February of 2015, you would not have jurisdiction now. Is that right? It's only because it happened after the first permanency hearing
Right,
that you have
because,
jurisdiction. If it
what-
happened
what-
before, you wouldn't have it.
Right, what would have happened or could have happened if the neglect petition was dismissed, and there was no order from the court saying return the kid under Article 10. The court never issued such an order. All the Article 10 order said is that the neglect was dismissed, but,
Well, that was my question before. Why is an order required?
well, I'm not sure.
If your
I'm not sure-
petition is denied.
I'm not sure an order is required, but I think
I thought that's what you just said.
the department's remedy, I think, would have been if the neglect was dismissed, there was no prior Article 10A order, we could have, I think, under this case, asked for a new removal order or asked for a stay, but I think, I mean, that would be our remedy for that, but
And what's wrong
Why
with
isn't
that
still-
remedy?
Yeah, what's wrong with that remedy now, though?
I think the problem is if you take what I'll call the legal snapshot, at the time the neglect was dismissed, there was an order placing the child under Article 10A that the mother had agreed to. There was a final order of disposition of the Wayne County Family Court. You just can't ignore that order.
Could
But when-
the department have filed a new neglect petition?
Well, we did eventually, but honestly, the reason that was filed is, frankly, we didn't know what the appellate division was going to do with this case, and we wanted that there for what I'll call insurance. And we just finished the fact-finding trial on that neglect hearing, and we expect to have a decision in a month or two. So that's been done, that's been filed, done, and litigated.
When I looked at the record and at the form orders for an order of fact-finding or disposition on an order of fact-finding in an Article 10 proceeding, there are all these sort of boxes to check and
Yes.
things like that. And in the area where it provides for a date for the next permanency hearing, the footnotes say that if the petition is dismissed, you don't put another date in that box or on that line. So does that tell us anything about the legislative intent?
I don't think so, because I don't believe the legislature drafts those form orders, and I think...
But is that how it's usually done? I mean, is this sort of an exceptional case because the court refused to allow DSS to amend the petition to conform with the proof?
This is an exceptional case, and I think honestly what happened is, the judge did say to DSS, to one of my attorneys, you should have amended the petition, okay? I think he was upset that we didn't, but I
Right.
think, on one hand, generally, courts are very liberal in allowing oral amendments. We've done that for you. This is probably the first case where a judge is just not allowed us to do an oral amendment, even when he sort of said you should do that, because this is a case where the judge...
I mean, you
knew
could
the
have appealed
background.
that, right?
He knew, because the neglect was about the first 7 days. He knew what the other information that he had before him that justified keeping this
Well, but
child in
that's
foster
my
care.
point. If, you know, for whatever reason, it didn't happen here, but if, as you say, in most cases, it would have been allowed, then presumably you would have had additional evidence to support your position that the child was in danger. And, which sort of leads me to my next question, which is, the standard of proof in an Article 10A permanency hearing is different from the standard of proof to either get a temporary order of removal or for a finding of abuse and neglect. And doesn't that lead to some absurd results, that somehow the state ends up keeping children in care when they couldn't have removed them or provided a basis for that in the first place?
I don't think between the two articles, the judges don't give a lot of weight to hearsay in permanency hearings. I think, frankly, we put the same proof in both hearings, and I think the court doesn't really treat these any differently.
Well, it's not just, well, but they're allowed to, and it's not just the evidentiary rules, but it's also whether there's imminent risk of harm, whether there's, you know, some risk and it's in their best interest. I mean, there are so many differences here. It just seems to me that it's a lot easier to maintain the child in the custody of the state while an Article 10 proceeding is pending or after a finding of abuse or neglect than it would be to keep the child where there is no such basis on the other side of the...
That's true, but also, in a lot of these cases, we have non-respondent parents, and we're keeping the child from them, too, because the judge has enough concerns on the record for that to happen. So even, you know...
Thank you, counsel. Counsel?
May it please the court, James Hinman on behalf of James and Jennifer Ryan, the foster parents. The thing about the Family Court Act is that it's structured in articles. Article 3 deals with custody and that's Article 6. Article 8 deals with family offense. Article 10 deals with abuse and neglect. And the legislature created a whole new article, Article 10A. It is, if they meant to provide protections under Article 10, they would have added subsections to Article 10. But they didn't. They created a whole new article, Article 10A, and they gave the court independent jurisdiction. The jurisdictional grant to the family court under Article 10A is entirely separate from the jurisdictional grant to the court under Article 10.
So your view is they created this entirely separate proceeding with an entirely separate standard from Article 10 that operates, even though it's triggered initially in the context of this Article 10 proceeding, continues to have a life of its own, even
Yes,
after
it does. Because to get into the Article 10A, there has to be an order from the court removing the child or one of two sections of the
Just
social
bring an Article
services law.
10A proceeding? Like, hey, I'm going to bring an Article 10A proceeding.
Can't.
Right. So doesn't that tell you it's tied to some other article?
It's tied to the social services law and Article 10A. What it's tied to is the location of the children. When the children are in placement, doesn't matter whether they're there under the social services law or under Article 10. That's when Article 10A kicks in after 6 months. As Judge Wilson observed, if the petition had been dismissed in February, we wouldn't be here.
Doesn't that potentially create some constitutional problems? And if that's the case, and if there are two possible interpretations of Section 1088, shouldn't we avoid that possible constitutional infirmity?
In a properly preserved case, I would agree with you that that's appropriate. That's not preserved here.
Isn't
What
that
was-
a rule of construction we apply all the time? You have to preserve it. It's just a rule of construction. I mean, if there are two interpretations of a statute and one of them is going to lead to some type of unconstitutional result, don't we as a general matter, you don't have to raise it, but as a general matter, we would apply the interpretation that preserves the statute?
It doesn't apply to the facts of this case. This child was removed prior to the filing of the petition.
We're not just interpreting this statutory scheme for this case. We're interpreting it for every case. So if that's what we're doing, then don't we have to follow these rules of statutory interpretation?
I have no problem with that, but the facts of this case don't fall under an unconstitutional interpretation of the statute. This child was removed with all of the protections afforded to the mother under Article 10. The mother had the right to ask for a hearing to determine whether or not the child was at imminent risk. The mother forewent that opportunity.
So should we make it easier for the state to keep a child from a parent, or at least equally difficult to have a parent return a child who has, if the parent has not been found to have done anything neglectful or abusive, as it is for a parent who has been found to have abused or neglected the child? Does that make any sense? In other words,
I'm trying to understand the question.
well, the question is according to your interpretation, the state's ability to keep a child from his or her parents is at least the same as it is for parents who have been found to have neglected or abused that child as for a parent who has been found not to have abused or neglected that child.
Correct, once the child is in foster care. And the
how did-
provisions of Article 10A are applicable.
Makes sense. What if a completely frivolous petition has been filed and an ex parte order of temporary removal is given, okay? And as has been said here, typically it may take up to a year for that petition to finally see the light of day, have a hearing, and find that there's no basis for this petition at all. And in that case, you're saying that the court has jurisdiction to continue placement?
If the statutory criteria is met, that return of the child to that parent would place that child at risk of harm, and whether or not it's in the best interest of the child. No claim has ever been made in this case that the mother is capable of caring for this child. In fact, the findings throughout have been to the contrary, other than the dismissal of the neglect case. And
Well, those findings are not before us, right?
yes, one of them's in the first permanency hearing. The second one is the order that's appealed from. The court made a
But
finding.
the first permanency hearing was on consent.
It was, and it included a finding that the mother consented to, that return of the child would not be in the child's best interest and would pose a risk of danger to the child. The second testimony was taken that clearly established that, and then the mother came back and consented, reserving only the court's authority under subject matter jurisdiction to make the order. And since then, the court has even determined that it's unsafe for the child to have a 2-hour supervised visit in the mother's home. So this is not a case where the state is using Article 10A to keep a child from a parent that's capable of providing care for the child. It is an extremely exceptional case that comes from the fact that the department was not allowed to amend the petition and allowed to go into further proof, but they have at subsequent hearings, and all of the due process protections have been afforded to the mother throughout the facts of this case and the way it has progressed. So a due process argument that might exist in theory and may apply to the practice of the folks in New York City, as in the amici brief, that's not what's at issue here. All of the protections were afforded to the mother here, and the court clearly had subject matter jurisdiction under 115C. Thank you very
Counsel.
much.
Counsel?
May it please the court, Sean Lair on behalf of the minor child, Jamie J. My comments, I'd like to focus my comments with regards to the time. We had a question with regards to the year, and is this standard, or is this customary? And I would say it is when you're wearing that defense hat, when you have the mom and she's not in a good spot. She can't take care of this child. That is a move that defense counsel makes.
But my question really was geared at the following. Does it make sense that the jurisdiction of the family court turns on how quickly the fact-finding hearing is held?
Well, I would suggest that it should, because in this case, you have a 7-day-old child who's then in the care and custody of foster parents for 8 months, the same foster parents. Those are the only parents this child knows. So now, because mother hasn't asked for the 1027 removal hearing, she hasn't brought a motion to dismiss if it's frivolous, she has not demanded a
DSS
fact-finding
didn't
hearing.
meet their burden. So how, aren't there already, as counsel has said, other ways to protect the child? But DSS filed a petition, they didn't meet their burden, now they've got to do something else if they think indeed that the child is in danger.
Except that we have an Article 10A order, plain reading of the statute
But
says,
my question is, aren't there other ways? Forget the Article 10A for one moment. Are there not other ways to protect the child that already exist?
well, I would suggest, you're right, there are, but for both sides of the aisle. There's other, defense counsel could have done things that she didn't do. She didn't, again, bring the 1027.
But it's DSS's
request.
petition, and they didn't meet their burden.
But now we're 1 year into this child being in foster care. And at some point, I would suggest the focus has to be on the child, not necessarily just the parent and what's in the
But that's
parent's
what I'm
rights.
saying. If there are other ways, and you've said there are, and we've already heard them laid out for us, there are other ways to protect the child, if indeed the child is in danger.
And I agree with you. I think DSS could have done something different. And my point is, there was things a mother could have done different to not let it get to the 12-month period. But what was going on in the background was she, as the 10A hearing pointed out, she's not stable. She's making bad choices personally. She's making bad choices with regards to her medical care.
That may support these other opportunities or ways that DSS can protect the child, no? But it's not about whether or not there's jurisdiction once the petition's denied.
I agree with you. There are other ways. But I also think under the current scheme, what they did was proper.
But
There's a
also,
10A rule
how long have you been an attorney for the child?
since her 7th day of life.
So since November 2014?
Yes.
And has the child had the same foster parents?
Yes.
I see. Thank you.
Thank you, counsel.
Thank you.
Ms. Woods?
Counsel described this as an extremely exceptional situation. I would say that's an understatement. This is literally the only time this situation has occurred anywhere in the state of New York, as far as we can tell. And anecdotally, I'm unaware of any situation in Wayne County where this has been raised at all as well. This is truly novel. And certainly if the legislature had intended this, what we all agree is an incredibly dramatic shift in how Article 10 functions, not only would we see it happening, but we would see it reflected in the legislative history of this statute, and it's just not there. There's not a single mention of a desire to create a separate track that can keep a child in foster care in perpetuity based on allegations that have been subsequently dismissed.
What could DSS have done when the petition was not sustained? What should they have done?
They could have appealed the fact that the
For the
petition was
stay?
dismissed, and there's the automatic stay. They had time to do that. They could have brought the petition that they eventually brought almost a year later. They could have brought that much sooner and held the child under that petition. Instead, they elect to bend the law to suit their purposes here, and we would ask the court to reject that.
Thank you, counsel.
Thank you.